going to be talking about patent law for fashion. Next slide, please. So the topics we're going to discuss today are an overview of understanding of how patent law and fashion intersect. So again, this is a conversation about patents with respect to fashion, and on one of the early slides, I'll define both of those for you. We're going to talk about how patents are obtained and their benefit, how they can be applied relative to fashion. Fashion sort of a subset of what you can get patents for, and a little bit about the future, really not the future, really the present of patents in fashion law. Next slide. So as a starting point, there's a case book that was published just a few months ago. I think it was in June, but I'm not certain of that. It's being used in law schools around the country. It's called The Business and Law of Fashion and Retail. The two people, Barbara Colson and Douglas Hand, are the editors of it. There were, I've forgotten, 15 or so, 20 chapters in the book. There's a chapter in the book on patent law. I'm the author of that chapter, and so this presentation is based on what's in that book, in that chapter of that book. I use this. I teach this at multiple law schools. So what we're going to have is a sort of a condensed version of what I teach in the law schools. The good news for everybody on the call is there is no quiz. There are no tests associated with this. And there are cases that are discussed in there. I'm not going to discuss the cases here because there's a lot of detail that's there that goes beyond a half an hour here. But regardless, please be interactive. I ask the students to be interactive, and I have to be honest with you and say that this year for the first time, I did not do this in person. I did it I taught it on video, just like we're doing it here. When I teach in person, I tend to be running around the room and tend to be really very interactive and calling people and all that. I'm not going to do that here. It's a little more challenging to do that here, but I don't want you to let that get in the way of your asking questions. So let's move on to the next slide. So first, we're going to define fashion as it's defined in the book. So by fashion, we refer to every design-intensive product on the market today. So it's not just apparel. It includes things like footwear and accessories and jewelry and eyewear and even houseware and home products. And it's not just the products themselves, but it also includes what goes into the products, what makes up the products. So for example, if we're talking about apparel, it includes the textiles. If we're talking about jewelry, it includes the metalwork, it includes making it, it includes using it in times. And in order to obtain protection in the fashion world, protection requires looking back at the entirety of the creative process. That is, what went into the design, what went into the manufacture, but it also requires you to look forward. So we're talking about how the product will be marketed, sold, and used. Used is a really interesting word here because 30 years ago, probably 40 years ago, products that were in the fashion world were just worn, but now they're actually used, right? They're interactive. You can do things with wearable technology, as an example. And protection also requires that if you're creating this, you need to take certain steps to protect yourself from illegally copying the products. Patents themselves, we'll talk about what's included in a patent in a moment, but patents themselves can be high tech, they could be low tech. We talk about patents with respect to pharmacology and medicines. One would think that the vaccine materials that are being used now are potentially patentable products, and perhaps these companies have applied for patent protection. Patents these days are very commonly related to computer and internet technologies. By the way, that relates to fashion these days. There are other things that patents can relate to, including methods of doing things, business methods, ways of conducting business, and methods of treating a patient. But for fashion, it can be specific to shoes, it can be specific to clothing, it can be specific to jewelry. Let's move on, please. Next slide. A patent gives people the right, people generally think, and if you've been in others of these seminars, you probably heard that people often think that patents give people a right to do something, but actually what it gives you is a negative right. It gives you a right to stop others from doing something, from practicing the invention, making it, using it, selling it, and so on. Patent rights vest only after the patent is issued. Patents tend to be limited in scope, more so now than before, actually. We'll mention that as we go forward. and they're limited in time. A utility patent, there are two types of patents we'll be discussing, utility patents and design patents. I'll distinguish between them. Utility patents last 20 years from the earliest filing date, design, roughly 20 years. There's some variation to that. Design patents last 15 years from the date they are issued. And patents are territorial. If you get a patent in the United States, it only gives you rights in the United States. It doesn't give you rights, say, in Europe or in Canada. But you can get patent protection in those other countries. So utility patents and design patents. Sorry, utility patents and design patents. So in order, there are a number of criteria. These are all statutory criteria. I just pause and say that patents are one of the few places that are exclusively exclusive federal jurisdiction. There are no state associated patents in the United States, all federal. It's in this Constitution as such. So there are utility patents and design patents. Utility patents protect functionality, design patents protect appearance. Utility patents, the fundamental requirements to obtain a utility patent are that the invention has to be new, which means that it was not disclosed to a patent office anywhere in the world prior to you applying for it. Not obvious, which means that it has to be inventive, if you will. And it has to be useful, meaning that it has to have some function. Patents are limited in the United States. These utility patents are limited to in the United States to human inventions. So machine inventions are not patentable. Courts have excluded certain things, including abstract ideas. Abstract ideas as a big category of things that have been problems over the last 5 to 8 years. The courts have been very, very active on how they define abstract ideas. Actually, they don't define abstract ideas, but they include mental processes, mathematical algorithms, meaning that you have to go past an algorithm in order to obtain patent protection. Design applications are the criteria include new, it has to be not obvious, those two are the same, and it relates to ornamental appearance only. And you can obtain, for a particular product, you can obtain both utility and design applications. There's a question in the chat box. It says, if you get a patent in the United States and apply for a patent in Canada or China and they reject the application, does it affect your patent? Meaning in the United States, I guess meaning in the United States. And at what point do you apply foreign? At the initial application or after the patent is granted? So to answer the first question, if you get a patent in the United States and there's a rejection in a foreign country, it doesn't directly affect your patent in the United States, but if it could be if the patent was later challenged by, say, a potential infringer. If there was, for example, a reference that was identified in Canada, and the reference is particularly relevant and the United States Patent Office missed it, it could be applied in the United States by a challenger, and there are ways to challenge patents after they're granted. At what point do you apply foreign? The answer is that there's a time limit for applying anywhere in the world. I'll just answer that now. I think it might be in the slides, but regardless, if you apply in most countries in the world, once you disclose your invention, say you go to a trade show and you disclose the invention, you've lost the ability to file for patent application. You have to do that before the invention is disclosed. In the United States, they give you a year to file that. But once it's filed somewhere, there are time limits associated where you can file in other places. And it depends on how you do it, but it's typically anywhere from a year to about 2.5 years. You have to file in foreign countries, depending upon where you first file. When you file for a patent application, the process is the same in most countries. This is how it works in the United States. You prepare an application, which includes two things. It includes a specification, which is a detailed description of the invention, and it includes claims. The claims define the scope of protection, and they have to be supported by the specification. You submit the specification and claims to a government agency, the United States Patent and Trademark Office, which is located near Washington. Once it gets inside the patent office, they send it to what they call an art unit. You can think of this as a department of expertise. So if you have a patent application that's related to a pharmaceutical, it'll go to a group that only looks at pharmaceuticals. If you're submitting a patent application that's related to textiles, it'll only go to a group that looks at textiles. And in that group, it goes to somebody called an examiner. examiners are lifelong government employees, and they're very focused. So if they work on textiles, they spend 40 years only working on textiles. They don't work on anything else. They do a prior art search to find references that might make your patent application not new or not or obvious over prior inventions. And then they often issue a rejection. Typically, about 99% of the time they issue a rejection. You have a second shot at it. You can then explain to the examiner why the examiner might have gotten it wrong, or you can change your claims to try to overcome that. Next slide, please. So when it comes to utility patents, and we're going to be talking about utility patents first here. Utility patents, you have to have a specification and a claim. This particular patent, which issued a few years ago now, this particular patent was directed toward a boot, a particular boot. Let's see here. Can we take the slide down for a minute? Or maybe you can see this if I'm on the slide here. This is
I can see it.
Okay, this is the boot. Let me lean back so you can see the entirety of the boot. This is the boot that we obtained patent protection on. And the distinguishing feature of this boot is this slit that's here on the side. And it turns out I can't really show this from here, but the slit, there's actually two slits here. The slit is there's a slit on the outside and there's a slit on the inside. So this is a double layer boot. Let's see if I can do this. This is kind of tough on its small screen, but in the middle there, if you can see it really carefully, there's an elasticized material in there. And the idea here on this boot was that, and it's only on one side, there's no similar thing on the other side. And the idea to this boot is that as somebody inserts their foot in the boot, this elasticized material, which is called a gore, this elasticized material stretches and then it goes back to its original shape. The benefit to this, and maybe you can see this here, is you can taper the boot much more so than you could previously do it. So the benefit to this is that you can end up with a tapered boot. Now a tapered boot has some argument, an improved appearance, but the idea here is that you could taper the boot by putting this in. Let's move on to the next slide. And so I talked earlier about the specification being a very detailed description. And so this is in the specification for the patent. This is a boot designed so as to facilitate inserting or removing the foot, absent any additional mechanical devices such as zippers. It's located, there's a slit. The slit is located on the inside of the boot and it temporarily expands. These are just words that I've taken from the patent just to show you the idea of the level of detail that's necessary to prepare this. The opening could take other forms as well. In this case, it didn't. It takes that form of that slit. And then if we go to the next slide, we can see the claim that resulted from this. And the boot has an upper section, including an outer shell and an inner lining. And again, absent any mechanical closures. That turned out to be very important in the prosecution of this patent application. That's one of the questions, I guess, that's come up in the chat. Did we get objections? And the answer is yeah. And we had to overcome some prior art. In particular, there was prior art that was related to, as I recall, was related to a skate, not a boot, but a skate. And that skate had mechanical closures. I think it had a zipper and I think it had strapping for closures. And so we added this terminology, absent any mechanical closures, was added to the claim. There were other things that changed too, but that's one example. And so it was a partial length opening. We talked about where the partial length opening was. And then just coming down as a material with elastic properties embedded in the opening between there. And so you can see the level of detail that was necessary in order to obtain patent protection. This patent was directed to a boot, right? It's just a boot, not out and nothing else, just a boot. Moving on. And so I'm going to give you, as we go through this, I'm going to give you examples of other kinds of patents that apply to fashion as well. So in this case, we have what's referred to as a system. Okay, so a system has multiple elements to it. In this case, just to show you real quick, the system has, I'm moving around my cursor. I guess you guys can't see that, sorry. The system has a device that attaches to your wrist or is associated with your wrist and in an app on a phone. So it's multiple pieces. And this patent was directed to a control system for controlling the signal that's coming back and forth between the wrist and the phone. Next slide. You can also have a patent directed to a portion of a device. This looks like it's directed to the Apple Watch. It's not. It's directed to the band for the Apple Watch, a band for the Apple Watch. So this was an Apple patent where they were related to the band. And specifically, it's to how the band closes, the closure device on the band. Next slide. Here's an example of another patent. This is related to the fabric. This was a non-woven fabric. And as I recall, the claims are also directed to a method of making the fabric. So here's a fashion-oriented thing. It's just related to the fabric associated with the, say, the apparel. Next slide. Another fashion-oriented patent. This is related to a method for making a shoe with 3D printing. Another example of where you can get patent protection from fashion. One more. And this one is a little bit different. This one is actually, this patent did not issue. We were not able to get this patent, but this is a patent directed to a security device. And the idea here is that somebody plates, say, a belt buckle or a rivet on jeans, and embedded in the rivet is, embedded in the plating on the rivet or the belt buckle are indicators. Say it's Levi's jeans, you may see the letters LEVI are embedded in there, and they're visible under certain, say, lights or under magnification. The purpose to that is for authentication of the device. So you can, so in the fashion world, because knockoffs are so prevalent, one thing you can do is securitize the device by introducing some element into the device. Next slide. So those are examples of utility patents. They can be directed toward a system, toward a device, toward a boot, toward a method of use, toward a method of manufacture. You can obtain utility patent protection for the entirety of a product or part of a product. So now we're going to move on. We're just to try to rush through this a little bit. We're going to go on to design patents. And so here's an example of a design patent that was directed to part of a shoe. Again, a design patent can be directed to a part of an element or the entirety of the element. This is to part of the shoe. A design patent also has to have a specification and drawings that depict the shoe. Sometimes in these days, there are times when you can use photographs, but it's not necessarily a good idea. And instead of having a whole bunch of claims that have a lot of detail, you only have one claim in a design patent. And the design patent claim says, essentially says, I claim what's in those pictures. That's it. Just to move on here, there are other examples of things you can get design patent protection for. This was traditionally done in the patent world, but design patents were really a very common thing. They were used for protecting elements. It used to be 14 years, now it's 15 years. If you have a particular design, particularly in the fashion world, like this platform for a shoe, and I can actually show you an example of what the shoe looks like in total. There it is here. If you have a design patent for the shoe where you're protecting just the bottom element, this bottom element, if you're protecting this stuff, 15 years is a really long time, because several years down the road, 3, 4, 5 years down the road, the design's probably out of vogue. So 15 years is a good opportunity, a good length to try to obtain patent protection. Design patents tend to be relatively less expensive than utility patents. They tend to issue quicker. So these were traditionally done in the fashion world, but now utility patents are showing up as well. So just to move forward on these slides, some other examples. Well, this was what I just showed you. Some other examples of things that were good for design patent protection are things like hats and handbags and other types of shoes. Let's move on to the next one. Here's a shoe that was designed by Mary Kate Olsen. There's a lot of patents that had famous people associated with them. Moving on, I said you can get patent protection for part of a design or the entirety of the design. The way you distinguish it in a patent application, in a design patent application, is by whether the lines in the pictures are dotted or solid. If they're solid, you're trying to claim them. If they're dotted, you aren't. So in this case, what these people, sketchers, obtained patent protection for was essentially the clasping of the lacing on the shoe, not the entire shoe, but just that. Next slide, Kendall. Here's an example of where somebody just got patent protection for the toe box, not the whole shoe, but just the toe box. And you see that that is solidly outlined. And here's an example of a ski boot. This one, just to show you, just to give you a concept, on that toe box that I showed you before, if somebody puts that toe box in on any shoe, essentially, they're potentially infringing. Here, there's a lot of stuff on this ski boot. And so they could do part of this, somebody could do part of this, but not all of this, and they wouldn't necessarily be an infringer on this. The next slide, please. So moving on, the drawings and design patents are the most important thing. The designs have to be clear and articulate. You can leave nothing to the imagination. You need to have enough views, typically 7, to show what's in the design, to completely show what's in the design. Typically, you need a draftsperson doing these things because you need to show surface shading. That's not easy to say very fast. Surface shading to show all of the character and the contour of all of the surfaces, and be able to show 3-dimensional aspects of the design. And we already talked about dotted lines or broken lines, which form no part of the claim design. Let's move on to the next slide. And just to compare the two, design patents protect the appearance, utility patents protect function. Again, we talked about the difference in how long they last. The number of claim, let me just point out, in design patents, in some sense, they can be extended past 15 years if they become very well adopted and they establish what's referred to in the trademark world as secondary meaning. You can then get trademark protection, trade dress protection, I guess, around those to extend it later. Design patent applications only have the one claim, and utility patents are unlimited. There's some other aspects, whether they're published, whether you have to pay maintenance fees, and the drawings and design patents are the most important thing in utility patents. They're important, but not to the same extent. I'm looking, there's a question here. Isn't the shoebox pretty common? I don't know. Maybe it is, maybe it isn't, but they were able to overcome whatever references showed up. That was not something that we had prosecuted. That was I found that online. So let's move on. We have about 3 minutes left, and we are going to just talk real quick about the future of the fashion industry. And the example is wearable technologies and some of the issues that pop up as an example, in wearable technologies. So wearable technologies, which could be related to, say, watches or eyewear, or if you think back to Google Glass, smart shirts, things that are wicking, and things that are looking at body functions like sleep. This wearable technology is sort of the bridge between the old-fashioned world where you wanted something to be aesthetically pleasing and also provide a function. So what ends up happening is it's really the convergence of 2 types of technology. And you have fashion companies who had previously been concerned with appearance and comfort, as an example, and technology companies who are looking to try to insert technology into these products. Do they apply to utility patents? Do they apply to design patents? And the answer is they apply to both. Next slide. An example is this, where you have a posture sensor that's also acting as a ornament that somebody would wear. When you have something like this, you have to start thinking about who owns the patent, who's the designer of this thing. Typically, these happen as a result of a partnership or a combination of 2 different companies with 2 different technology skills, but the companies haven't really merged, right? You have 2 different companies that are providing both pieces of this thing. Let's move on to the next slide. And so the issue on this is who owns this? When you file a patent application, you have to identify who the designer is, who the inventor is, and so it could be more than one person. You have to you have to identify who that is, And then there has to be an owner of the patent. So what really has to happen is if you have two companies, one say a technology company and one a fashion brand, they need to have an arrangement put together before they even get into this about who's going to own it. Maybe they're going to set up a joint venture, but regardless, somebody's going to own it. Somebody's going to be responsible for taking care of the patent as it works its way through the process at the patent office. That all has to be decided up front so you don't have issues later on. Who owns the design? Who owns the technology? Is it licensable, right? Fashion company might not want it to be licensable, but a technology company, it's not their product. Ultimately, the product is being sold as a fashion product. They may not care. So when you start getting into these issues about with wearables, you have to start worrying about who owns the product, how it's going to be handled, and you really need to take care of that as an upfront arrangement. That's not something that really lends itself to worrying about later. So let's move on to the next slide. And so I think we're just about done. I tried to keep this to half an hour. I think we started 4 minutes late and we're going to end pretty much in 30 minutes. So our goals for today were to understand how patent law and fashion intersect, how you obtain patents and what their benefits might be, how patents can be applied relative to fashion, and a little bit about the future or the present of patents in fashion. So I'm going to stop there. Thank you for your time. I appreciate it. I hope everybody's doing well. And if there are more questions, have at it.
Feel free to ask anything you would like. Thanks everyone for joining us.
If that's it, Kendall, if there's anything else you want to add, otherwise we'll. Somebody has a question. I see Elaine.
I have a question.
Yay!
Okay, this was really a wonderful presentation, very clear for the layman.
Thank you.
I have a question from, I'm a professional, but also a layman in this area. For an intellectual property, let's say that you're licensing a name, covers a whole category of wearable technology. As an example, my partners and I are involved with a startup, which has been somewhat stymied right now because of the pandemic, but it is for a process that protects you against electromagnetic frequency, EMF, which comes from cell phones and is going to be big time from 5G technology. We have already started to work with a number of manufacturers. We're looking at the apparel industry as the most logical place to do this. And our product, we don't make the products, but we are basically licensing others to make the products, and they involve fabric with a metallic component. And we have trademarked our name. It sounds to me, after hearing your presentation, that we might have an opportunity to patent this technology, even though the technology has existed in a variety of guises in the textile industry, primarily in Europe, for many years, and has been used industrially, but we're going to be using it in a new way. Does it sound like this is a patentable product in addition to trademarkable?
So let me, let's talk, the answer is, I think there's potential, but there's two different, going back to what I had been talking about, there's two kinds of things you can, among the things you can get patent protection for, there are two kinds. There's the product itself, and then there's the method, for example, the method of manufacture or the method of use.
Right.
It sounds like, actually I know this, that embedding metallic threads in a fabric is a technology that's been around for 100 years. Mm-hmm. But when it comes to electromagnetic related stuff, maybe there's something that's done differently in the manufacturing process. Maybe the threading is different in some way. I'm not going to guess about what that might be. And if it's being used in a different way, then the answer is that you have methods that that potentially are patentable. Now, when I say, I use the word potentially, admittedly, because I have no idea what other references might be out there. I have no clue. I'm not an expert in this field, but the potential does seem to exist, and it's probably worth looking to see if that's the case. If the technology is, and one other point to make is, if the technology and the method has been around for more than a year, even if you've done it for more than a year because you've been trying to do it, then the likelihood you can't get patent protection. It's already too old, but you've lost that right. But if there's something that changes over time, then potentially you have something. It's worth investigating.
So if I understand you correctly, we've been working on this for 3 years, and we have a trademark name as an intellectual property. For us, we want to license apparel manufacturers to use this technology, allow them to buy the products. We're finding them the partners, but it's being used in a different way. It's never been used for this before, and we have yet to produce it. We are still in the startup phases. This takes a long time.
So if you've just, so it's a question of, this is sort of we should get into this offline, but if there's it depends on how you've disclosed it, right? And it depends on what protections you've taken in the disclosure as to whether that year has expired or not.
Okay. It sounds like I need to come and have a consultation.
Yes.
I have a follow-up question, which would be good for the group regarding this. Can a U.S. examiner reference prior art outside of the U.S., like this lady said?
No.
Europe?
Absolutely.
No one has ever done it.
Do they do that?
They've never used this.
No, I'm asking Barry. Excuse me.
Oh, I'm sorry.
I'm asking Barry whether or not a U.S. examiner does reference prior art outside of the U.S.
Yeah. So prior art is not limited to previous patents and previous patent applications. It can be a technical article. It can be a journal article. But the fundamental answer to your question is yes, that a U.S. patent examiner can cite to a Japanese reference, and a Japanese patent examiner can cite to a European reference, right? There's nothing that stops people cross-border on that.
So does your firm, when they do a prior art search worldwide? I mean, that's huge, right?
Yeah, that's typically how it's done. You don't have to, but it's typically how it's done.
Okay, thank you, Barry. Excellent. I really appreciate your presentation. It was very clear.
Thanks, Max. There's a question in the
Thanks,
chat.
Max.
There's a question in the chat room, if I could just get to it. Is the shape of a new dress patentable? The answer is, and that's from somebody, AA, I don't know who AA is, but is the shape of a new dress patentable? The answer is, it may be if the design is a unique design. Remember, if the ornamental appearance of the shape of the dress is completely different than whatever anybody else had done before, it's potentially patentable from a design perspective. Utility perspective is more challenging, but a utility perspective, if the shape of the dress provides a benefit that is distinguishable from previous benefits in previous dresses. I can't off the top of my head think of what that might be, but if the shape of the dress allows you to add some kind of new accessory that previously you couldn't do, I can't imagine what that is, but if there's something like that, then the answer is, yeah, potentially you could get patent protection for it.
Hi, Barry. This is Judy. We work together every day. I have a question from a fashion designer. So this relates to when a fashion designer comes up with a particular design similar to artwork, for example, a monogram or a drawing that they then want to have on a t-shirt or on an article of clothing. Do they need to copyright their artwork in addition to getting the design patent or trademark?
Okay, so first off, just to let everybody know, Judy and I do work together every day, but Judy and I have not seen our faces since March. So,
I hope you're not in shock.
so it's good to see you. But secondly, the answer is that very simply, I'm not an expert on copyright, so I don't really want to get into that. But the artwork that would be used for the T-shirt, that artwork is a matter for copyright protection. And there are a bunch of ways you can get copyright protection. Some of it is just by putting it down on paper, but there are other rights that you can accrue by applying for copyright registration from the United States Copyright Office. That's not part of the Patent Office. But so the short answer is yeah, but you cannot, just by putting art on a T-shirt, that's not patentable.
Awesome.
I wanted to follow up on that question really quickly. Is that under industrial design or just under traditional patent?
So Barry, so a design like like a design that goes on a T-shirt, which is copyrightable, yeah, which is actually better than patent because then you have it's forever or 50 years, something like that. But that's not considered ornamental then. You can't consider that ornamental.
No, that's not considered to be part of the ornamental appearance. That's just let's call it an artistic creation. It's no different than music, for example.
Okay, can you hear me now?
Yes, there we go.
Okay, all right, yeah, so I just wanted to follow up to understand clearly. So he said that it's patentable if it's unique and new and never been done before. But does that fall under industrial design? Because I thought patents are mostly for technical stuff that is inside, technological inventions. This is regarding address, by the way.
Yeah, well, that's so the design, let's go back. So the design, if the appearance of it is novel, if for example, and I don't have a good example of this, but if for example, the dress has a hemline that's variable in some way that nobody else has done, then you can get design patent protection for it. Utility patent, again, is potentially possible if there's some benefit associated with that shape. But off the top of my head, I can't come up with something that would really be a benefit that would apply for utility application. But if the dress has something again, the two requirements are that it has to be new and not obvious over prior inventions. And a way to think about not obvious, this isn't literally true, but a way to think of it is that not obviousness means there's got to be something inventive about it. So if the dress, again, using the hemline as an example, if you have a variable hemline, meaning that it has a wave to it, but somebody else has a longer wave or a shorter wave, then maybe that would not meet the requirements. But if there's something particularly special about the appearance of the dress, then you could get design protection for it. And that's, and to kind of address the comment that you made about technology, patents don't necessarily have to be directed toward very high-tech stuff, right? It could be directed to some low-tech stuff. I always, when I meet with clients, I like to give the example of the sleeve that goes around the Starbucks cup, right? That stops your hand from burning. That sleeve is just a piece of cardboard with a dab of glue on it, right? There's nothing really ornate about it and nothing really expansive about it, but it's a simple design and they made a fortune on it and it serves a real strong purpose. So it doesn't have to be really high tech.
I think there's one more in the chat, Barry.
Yep, I'm looking at it right now. When the dress hem, with the dress hem example, if the manner in which it was cut had the result that it would not, for example, move around and would hold pleats in place, would that potentially be covered by a utility patent? Potentially, yeah. Potentially, yeah, if it had something like that. But again, it has to be new and it has to be inventive, not obvious over prior inventions. And so the answer is potentially. I mean, to this question, just to go back to the boot, go back to this boot, and think about this for a second, right? This turned out to be both new and not obvious over prior inventions. This is a really simple design. And so it's simple, but it's very clever. So, you know, you have to think of it from that context.
I have another follow-up. If you found someone selling something in the store that's identical to the shape of a product that you have, like a dress, for example, completely identical essentially, and selling it in the store and passing it off as theirs, but it's sort of a trademark of yours. What type of, is that something that's a trademark infringement, I would suppose? And that's something that you can go after them for, but what would be, like a legal action to take? I mean, I thought about a cease and desist letter to essentially stop them from doing that and selling that, but what would be, I'm just curious in your
Well,
opinion.
you could do that. That would be a good first step if you decided that they were really that similar to each other and that you actually had protection on it in some way. So that's a potential first step. Ultimately, you could start a litigation against that person. That has pros and cons, right? So, but yeah, you could do that.
Okay. So that's a trademark infringement and IP protection. So we can start a litigation against them. And also if it's a product that we sell in our store that we didn't make, but essentially, made from another manufacturer, but we carry it and they're selling something still similar. That's also something that we can.
Well, then the question is who, if you're the retailer, and it seems like then it's the manufacturer that would actually have standing to sue on that, not you as the retailer.
Not us.
Yeah, but again, I'm not, I said before, I'm not a copyright person. I'm also not a trademark person. So, I would refer you to somebody who does trademarks all the time to.
Okay. So it's
Yeah.
trademark and copyright issues essentially, and not necessarily like IP
Yep.
roads. Okay. Cool. Thanks so much.
Yep.